Hello, everyone. Welcome back to the Immigrant Blueprint panel, where we discuss and we also help you navigate the complex world of U.S. immigration law. I'm Ebony Anaforo. I'm an immigration attorney in New Jersey. However, I work with clients in all 50 states and around the world with their immigration. And today, we're going to be tackling a big question, and that is, can you still get a green card if you have a criminal record? For many people, this is a sensitive and very overwhelming topic, but understanding how criminal records can impact your application is crucial. So, if you or a loved one is concerned about how past mistakes might affect your future, I want you to stay tuned because this video is for you. First and foremost, when applying for a green card, honesty is a non negotiable. U.S. Citizenship and Immigration Services, also known as USCIS, will ask for a complete account of your criminal history, whether those incidents happened in the United States or in another country. Minor traffic violations, such as pending tickets, typically will not cost you any issues. However, crimes that are more serious, like DUIs, theft, or drug-related offenses, must be included in your application. Now, why is this important? Because USCIS conducts a thorough background check as part of the green card process. If they discover that you fail to disclose something, whether intentionally or unintentionally, it can lead to severe consequences, including a denial of your green card application or worse, removal proceedings. So even if the charges were dropped, expunged, or even dismissed, make sure to disclose them. When in doubt, include it. Always better to explain the situation up front rather than to have USCIS think that you are hiding something. Okay? So now let's talk about crimes that could make you inadmissible, which means that you're ineligible for a green card. All right. So I want to break down the three main categories of crimes that could make someone ineligible to eventually get their green card. These are important to know because not all crimes are treated equally when it comes to immigration law. So, number one, aggravated felonies. Aggravated felonies are some of the most serious offenses in immigration law. Now, this includes crimes like murder, drug trafficking, RAPE, and even some theft-related offenses that involve significant financial loss. What's tricky is that something that's classified as a misdemeanor under state law could still count as an aggravated felony in immigration law. So that's something that you want to keep in mind. Don't just assume that you were not charged for a felony and it was only a misdemeanor and that it doesn't fall under the aggravated felony category. The next category is called crimes involving moral turpitude. And these are crimes that involve intentional dishonesty or harm. Think of things like fraud, theft, or assault with the intent to harm someone. The key factor here is your intent. So if the crime shows that you had bad moral character or malicious intent, it can cause problems for you on your green card application. Drug convictions are another red flag. Most drug-related crimes will make you inadmissible for a green card. However, there may be some very narrow exceptions. So you want to speak with an immigration attorney to see whether or not you qualify. However, in general, any drug trafficking or distribution related drugs will likely result in your ineligibility of a green card. Okay? So how do you disclose your criminal history properly? When you're completing forms like the I-485 for adjustment of status or the DS-260 for consular processing, there will be specific questions about your criminal history. So I want to talk about how you're going to handle answering those questions on your application. So number one, you want to be upfront. Clearly describe the incident, including the time of the offense, when it occurred, and where it happened. You want to gather all supporting documentation. This includes police reports, court dispositions, and any other records that detail the outcome of your case. You want to explain mitigating circumstances. So, for example, if the incident happened many years ago and you've since rehabilitated yourself, include evidence of your good moral character, include letters of recommendations, community service records, or proof of your rehabilitation. Okay. You want to include as much information as possible. You do not want to give immigration the impression that you're withholding information about your criminal history. Now, if you have a criminal record but still want to apply for a green card, you may be eligible for a waiver of inadmissibility. A waiver essentially is you asking the government to forgive you for your past actions and let your application proceed. To qualify for a waiver, you must typically show that one, you do not pose a danger to the United States, that refusing your green card would cause extreme hardship to your US citizen or green card holding family member. For example, if your spouse is a US citizen and they depend on you financially or emotionally, or even if they have some underlying health issue and depend on your support, that could be considered extreme hardship. But I want you to keep in mind that some crimes like murder or drug trafficking are not eligible for waivers. So even if you qualify, obtaining a waiver can be a very lengthy process and it could be a complicated process. So you want to have a skilled immigration attorney on your side to assist you in preparing this application. So if you qualify, work with an attorney. Do not attempt to do this on your own. I cannot emphasize enough that if you have a criminal record and are applying for a green card, the importance of working with an experienced immigration attorney. It is essential. Immigration laws are highly complex, and criminal convictions can often fall into gray areas. Okay. An attorney will be able to help you evaluate whether your conviction makes you inadmissible. Okay, so having a criminal record does not automatically mean that you can't get a green card, which is why it's important to have your case evaluated by an attorney. An attorney can determine whether you qualify for a waiver and also guide you through every step of the process to ensure that your application is strong, right? You want to always present a very strong application when applying for immigration benefits. Okay. So even though you have a criminal record, it does not mean that you're automatically ruled out from getting a green card. You do, however, want to make sure that you're speaking with an immigration professional who has experience helping individuals with these types of circumstances. Okay. Well, that's it for this video. I want to thank you for tuning in and staying with me to the end of this discussion. If you found this information helpful, please give this video a thumbs up, subscribe to our channel, and also share this video with someone who might benefit from it. If you yourself have questions about your immigration case and you want to explore your options, you can feel free to reach out to my office for a consultation. You can call our office or you can book directly online. And as always, I want you to remember that every case is unique and you want to make sure that you're getting the right advice so that you can take the first step towards success in your immigration process. Again, I am U.S. Immigration Attorney Evian Foro, and I will see you in the next video. Take care.